Good morning, everybody, and welcome. Thanks for being here. I'm Neil Chase. I'm the CEO here at CalMatters. I want to welcome everybody to our Sacramento session this morning. We are especially pleased to thank our new sponsors for these events, Lucas Public Affairs, new sponsor but longtime friend of ours and a good partner to us, so very happy to have their support to make these events possible, both for the people in the room and for the several hundred who've registered online. We have a pretty significant virtual audience with us this morning as well. So I appreciate you being here both in Sacramento and around the state and around the country. Very important topic to discuss this morning, one that that we've covered, other people are talking about, and we really believe strongly here at CalMatters that bringing people together for a conversation, getting the people in the room who understand the problem, who can talk about it, who can discuss the possible solutions, and bring the community in for a conversation about it is one of the ways you get to the solutions to some of these problems and issues. So we're very thrilled to have the panel here. Thrilled to have you here to be with us, and I want to turn the leadership of this over to our reporter, Nigel Dwyer, who's going to take it from there. Nigel.
Neil, and we on? Okay, here we go. Thanks everyone for being here too. For years, California legislators and some advocates wanted a statewide law that took police shootings out of the hands of local prosecutors and police and put it in the hands of the state. In 2020, after the death of George Floyd, California passed a raft of police reform bills. Among them was a watered-down version of a police shooting bill called AB 1506. Instead of investigating every police-caused homicide, the law would limit it to police shootings. And instead of investigating everyone killed, the law would limit it to people who were unarmed. CalMatters has been reporting on 1506. Between July 1st, 2021, and today, there have been 39 cases opened by the Justice Department, the state Justice Department. The state has closed just 3 of those. Some investigations are at 20 months and counting. So today, we're here to address the law under AB 1506, and our panelists are here to tell us how the law can be applied and maybe how it can be improved. Diana Becton, to my left, is a district attorney for Contra, Costa County. Following her appointment for the Board of Supervisors, she was elected to the position in June 2018 and re-elected in June 2022. She's a member of the Progressive Prosecutors Alliance. Please welcome Diana. The gentleman in the police uniform there is Ed Obayashi. He's a deputy sheriff and policy advisor for the Plumas County Sheriff's Office, and he's a licensed attorney. He's also worked with the Justice Department on police shooting cases. Please welcome Ed. Last but not least, Greg Totten became the CEO of the California District Attorneys Association in January 2021 after retiring as the elected DA of Ventura County, where he was DA for 18 years. Please welcome Greg. Right, thank you all for being here. So, first, Diana. Tell me what it was like investigating these kinds of cases before 1506, when it was police shooting cases handled at the local level.
Thank you. So I think I'll start out by addressing your question just to think about some of the reasons behind AB 1506. And I think a large part of it, as you mentioned, this legislation was passed following what happened with George Floyd. And a big part of the passage of the legislation really has to do with the community's distrust of having local DAs make the decisions in these kinds of cases. And so it kind of goes from there to be the type of legislation that's supposed to help build trust and confidence and have a sense of transparency with respect to these investigations. So I think that's one of the reasons why we have 1506 implemented. What it was like before, it simply meant that the job that we do as district attorneys in California means that we investigate not only the officer-involved shootings and incidents in our own counties where there is an armed person, but also an unarmed person. So that's the most significant change, that we no longer take the cases where the citizen is unarmed.
Was there anything different about investigating police shooting cases as opposed to a homicide case, specifically a lethal OIS case?
Well, I think there's a lot, there's a lot of nuances, and I'm sure that we will get into those as we go along. One of the biggest things about this type of change is that we have a major, major change in our system. It is a major change in terms of the way that we do business. And so even in our own local communities, some offices may have already had policies in place regarding greater transparency with their communities. I can say that in Contra Costa County, that did not exist. So in 2018, I announced the decision to make sure that for every case where we were investigating and we were not charging, that we would issue a thorough report so that our community could see and understand the decisions that we're making, and also have greater transparency and trust with our communities and with the law enforcement officers that we are investigating. But to institute that kind of change is a major, major undertaking, is really the age-old question of how do we change, how do we affect institutional change? How do we affect change in an office or in a place or in a state even that has not been accustomed to doing something in this particular way? So we're really talking about setting up procedures and policies to do something that we have never, ever done before.
Speaking of those uniformed officers, Ed, as a police officer, what were investigations of other officers like before 1506 when it was a homicide investigation involving an officer?
Really, as far as the nuts and bolts are concerned, nothing's different. The public has to appreciate that these type of investigations, whether armed or unarmed, by definition, take an extraordinary amount of time. I have one case right now that I'm investigating. It's been going on for 3 years, and I've been working at it constantly. There are a lot of nuances, technicalities, legal issues that intermingle with each other, and the fact that AB 1506 investigations have taken up maybe, as Nigel mentioned, maybe 2 years, that is not unusual at all. They're highly complex. You have two levels here that you have to kind of connect, and they are connected regardless. You have the investigatory function by the investigators, which, as I mentioned, takes a lot of time. You have forensics, you have evidence analysis, witnesses, a lot of forensic sciences come into play. Contrast that to, say, I hate to use this term, the run-of-the-mill shootings that you have out there every day. Those are pretty straightforward, generally speaking. But when it's an officer-involved shooting, and I'll probably get pushback on this, the presumption is that the cop did the right thing. That's the societal policy, and it's also the legal policy. That's why you give us a badge and a gun. So when we use force, or we involved in an officer-involved shooting, the presumption is, okay, the officer followed policy, the law, and his or her training. Now, you're not going to satisfy everybody, because again, the idea here is if the investigation is leading towards the conclusion that the officer did the right thing, someone is not going to be happy. So you have to get it right. So that's an investigatory issue in a nutshell. But now you have the prosecutorial function, and that's going to take just as much time, if not longer, because again, the legal analysis, et cetera. AB 392, the new use of force law, which affected the use of deadly force by police officers, has further complicated that analysis because it's a brand new law. And many DAs and police trainers, we do disagree about the impact of AB 392. So that's another factor in terms of analysis. So again, to answer your point, it really hasn't changed. It's as difficult, if not more complicated, than it's ever been.
Sure. And just so AB 392, of course, is governing the officer's use of force, basically, right, to deciding what it is. And just to follow up real quick, Ed, so would you agree then that when the Attorney General said that these investigations should be completed within a year, that might have been overly optimistic?
Well, I'm not saying it's overly optimistic. I think it was hopeful. And again, we strive for that. I have seen investigations. I've done investigations in less than a year. But again, they're all different. But the norm is that it can, just one unknown or unexpected factor or element comes into play will extend that timeline dramatically. And there's no predictability regarding that.
Greg, thank you for waiting for your question here. So when this law was being proposed, attorney generals, or excuse me, district attorneys were divided somewhat on it. There was some question over them losing power, them not being able to sort of investigate cases in their own backyard. Do you remember before the passage of the law, and certainly I know you took office in 2021, but what the mood was like among DAs? Were folks excited for this, or were they kind of pushing back?
Well, I think a number of district attorneys actually supported the proposal, and the association didn't take a position directly on it. But I don't, from my perspective as a prosecutor who's personally reviewed these cases, who's personally gone to officer-involved shootings and the scenes and been part of a interview of an officer afterwards, I didn't see this law as a terrible thing or controversial. I understand the concern that many members of the public and members of the legislature had with the closeness of local prosecutors' offices to individual police agencies and police officers, and just the public perception of that. But let me say something that is kind of overarching. The role of a prosecutor in reviewing any criminal case, including those involving officer shootings, is, as articulated by the courts generations ago, is our role is that neither guilt shall escape nor innocence suffer. And we are, in every sense of the word, a check and balance in the criminal justice system. Law enforcement investigates, they present cases to us, we review those cases. To file a criminal case, whether it's against a peace officer for an officer-involved shooting or some other charge against some other civilian, our responsibility is to only charge those cases in which we believe we have sufficient admissible evidence that would persuade a neutral trier of fact, a judge or a jury, beyond a reasonable doubt of the truth of the charge. That is the highest standard in the law. And so our responsibility is a solemn one, and we take it very seriously. With regard to AB 1506, I think with such a major change, as Dinah mentioned, in the law, there are naturally going to be fits and starts. There's been a lot of training. Ed's been involved in some of that. The DA's Association that I serve has been involved in some of that. And there's been a lot of training effort for DOJ and a development of a protocol, I think the Department of Justice, tasked with this responsibility, which is immense, has tried to do their very best from the standpoint of serving this responsibility they have under the law.
Sure, and we should note for AB 1506, the result isn't, was the officer's action in policy or out of policy, was the officer a good guy or a bad guy. What they're asking is there sufficient criminal evidence to file charges against the officer? So far, in all three of them, there has not been, but these reports, as Ed can tell you and these other folks can tell you, sometimes run to 120, 150 pages. So these are intense, in-depth, long looks at what they can do and then also what policy and practices can come out of this. So Ed, on that note, this is a new program, as everyone has noted. This is something that folks haven't done before. So how are these investigations distinct from, as you mentioned, run-of-the-mill homicide investigations, and why might they be taking so long in this specific instance? What about the investigators, et cetera, might be doing that?
Although AB 1506, places that investigative responsibility, primary investigative responsibility on DOJ, it's important to understand, though, that this is a collaborative effort, not just by DOJ, but also with the local agencies in that jurisdiction in which the OIS occurred. So it's not like DOJ has the total, they have the ultimate responsibility, yes, for unarmed shootings, but it very much is a cooperative effort. So there's a lot of, assistance. Everybody wants to do their best and assist each other to reach that ultimate conclusion. Now, that said, the when it comes to investigating officer-involved shootings, there is a much more intense effort by necessity as opposed to the, as I said, the regular unfortunate shootings that we witness every day, because there typically is, let's put it this way, when we have a robbery and the bad guy shoots the victim, you got witnesses, you've got the smoking gun, you've got the cameras, it's pretty much a straightforward investigation, right? But when it comes to, so in other words, there's a presumption, okay, yes, there's a presumption of innocence, but there's a presumption that, yes, the suspect did that, and it was for a bad reason. As I mentioned earlier, when it's an officer-involved shooting, you have to flip that thinking around. So you start with the premise that, okay, this officer more than likely did the right thing, unless there's something so obvious, fact-wise, that says, no, something is very bad with this shooting. And yes, that does come up. But then in today's world, as opposed to when I started, you have body-worn cameras, you have cell phones everywhere, you have CCTVs everywhere on every corner. All of that evidence now adds dramatically to the type of analysis that's required. Officer-involved shootings, we're going to grab all that video evidence, whatever video, audio evidence, et cetera, and we're going to analyze that frame by frame. We're going to go over that hundreds of times. In my investigative classes and courses for DAs and officers, I stress that you just don't look at a video once and come away with a conclusion. You've got to study that video literally, it may be 100 times, different videos, correlate the videos, et cetera. So that's just one aspect of it. Plus there's going to be 3D recreations of the scene, which we rarely do in the, say, the typical criminal scenario. That takes further time. Forensic evidence, ballistics, and the witnesses too. Sometimes we get a witness statement within, say, 3 days, maybe longer, depending on what the protocol is. And that's another issue that comes up. We don't typically interview the involved officers immediately. There's a certain protocol involved in that, and that's delayed. But as I stress, and any investigator will tell you this, there's no such thing as a one-and-done interview when it comes to an officer-involved shooting. You have to let's put it this way, I don't want to get into forensic sciences, but cognitive analysis, but memories can improve over time. And we do have to go back and clarify a lot of different issues, each and every single one of them, because as I mentioned, you're not going to make everyone happy on this, but you got to do the best job you can. As we talked about this, it was years before I was allowed anywhere near a use of force investigation, never mind an officer-involved shooting. So it's very complex.
Greg, did you want to say something?
Yeah, just let's be clear on this AB 1506. It is limited because it only authorizes and empowers the Attorney General to conduct officer-involved shooting investigations when the civilian that was killed was unarmed. Nationwide, there's about 1,000 police shootings, and about 4% of those cases involve individuals that were unarmed. So still the vast majority of officer-involved shootings are being conducted by district attorneys like Dinah Becton and other prosecutors, local prosecutors across the state. Part of the reason these investigations are so complex is because in addition to the criminal investigation that has to be done, there is generally a concurrent administrative investigation or professional standards investigation that is being conducted by the agency employing the shooting officer or officers, as the case may be. And that investigation is a personnel-related matter. Did the officer comply with policy? Did the officer go outside of policy? Is there a need for some kind of disciplinary action involving the officer? Another complicating factor is, like anybody that is a suspect in a criminal case, police officers have a right to not give a statement. They have a right to remain silent. Certainly from a prosecutor's perspective, we want that statement. Oftentimes in these cases, we're dealing with situations where the only two individuals that were present at the time of the shooting is the shooting officer and the decedent. And so if we don't have we obviously are not going to have a statement from the decedent. If we don't have a statement from the officer, it can immensely complicate and make much more difficult our conclusion as to whether or not the shooting is justifiable or not. But today as well, we have body cam footage. It's not uncommon in these cases to have a huge volume of body cam evidence that you have to review. It's also not uncommon for the original investigating agency that has jurisdiction where the shooting occurred to take as much as a year to complete their investigation. They take these cases very seriously. Their investigations are very comprehensive. So by the time the Attorney General or a local prosecutor gets the case for formal review and additional independent investigation, it's not uncommon for as much as 12 months to have passed since the shooting itself.
Well, so as you noted, this is a very specific and limited law. Police officers who shoot not cause a homicide in any other way, and the civilians, the people who were killed, are unarmed. But, Diana, Kevin McCarty, who proposed this bill, who got it passed, has also proposed the DOJ taking over all homicides caused by any officer, regardless of whether the person was armed or not, regardless if it was a shooting, hit him with a car, whatever. And it should all be done at the state level. What do you think the future is of officer-involved shootings? Does it go that way?
Well, that is a conversation, actually. It's not a new conversation. It's a conversation that has been tossed around for a number of years. And I think what you're hearing from us today is that even though I would not personally, I can only speak for myself on this panel, I would not personally oppose the DOJ being responsible for all of those investigations. I think what you're hearing today is that what it would take to get us to the place of being able to actually implement such a plan would be a tremendous, tremendous lift. One of the biggest barriers to being able to stand up investigations statewide for all of the officer-involved shootings, of course, would be money. Because not only would you have to pass the law, you would also have to fund the agency to be able to ramp up, to hire all of the personnel that's needed to be able to do the job, not only on the investigative side, as you've heard much about, but also on the side of the legal analysis. And then don't forget, we haven't talked about this a lot because we've gotten kind of into the nuts and the bolts of the nuances of the investigation and why it's so unique and why it's so different. We haven't talked about what it takes to even get ready to do the investigation, the big lift that it takes to put the systems in place. I can speak for Contra Costa County because not only did we have to put in place the policies, not only did we have to put in place the teams on the investigative side, but the teams on the legal side to be able to conduct these investigations in a knowledgeable way. There had to be a training that went into play before we could send people out in teams to be able to conduct the investigations. And by the way, Contra Costa is a little bit different because we have a protocol. We have 25 agencies in 19 cities that we work with, but all of our agencies have agreed to a protocol whenever there is a fatality. And so we are on the ground from the beginning doing a co-investigation. So not only did we have to train internally, but we also had to train externally because all of our law enforcement agencies, I just mentioned that we have 25 agencies, they also had to be informed about what we're going to be doing, what we're doing different internally and what we're going to be doing differently on the scene. And so it's very easy to say, let's put this in place, but it also takes a tremendous amount of planning and a tremendous amount of power to be able to implement all of the changes. And so you just think about that. I'm only talking about our local agency. Think about that on a statewide level. You'd also have to have a change in the way that each individual county is conducting their investigations, because you'd have to be thinking about whether that agency is still going to be involved, whether the DOJ is going to be able to deploy personnel to be there on the ground in an expeditious manner to be able to take over the investigations. There's a lot that goes into that. So I think it's a conversation that's worth having, but I also understand that there are a lot of challenges that would go into putting that in place.
Hope I'm not telling tales out of school. It wasn't the easiest thing in the world for those investigators, right, who were working on the police shooting cases in your office.
No, I would not call it easy. I would not
You have
call
to
it
take
easy.
any specific measures that
Well,
you,
one of the things that happened in Contra Costa County, and I think we are probably, again, unique to a number of counties, is that when I came on board, we essentially had one person, an attorney, who was leading our investigative team and also being responsible for the legal analysis and making a recommendation. And we knew right away that it was important to move from an individual person, just for the optics and the community trust in what we were doing, to move from a person to a team approach. And yes, that took some time because, as I said, you have to build the teams. You have to build the investigative team. Now we have a totally different approach, so that our chief of investigations and has a group of lieutenants who will be on call 24 hours a day. We have a group of investigators who are on call 24 hours a day. We have attorneys who are now on call 24 hours a day. So we had to build all of that, and then we had to put in place the training. And again, as I said, it was not just training internally, but also training externally with all of the law enforcement agencies that we work with. So it was quite a lift, and I would say that from the time we announced the policy in 2018 that we're going to issue this public report to actually being able to put in place the systems and the people that we needed to actually issue those reports probably took roughly 2 years.
wow, okay, just to get that going. And specific to the money, something we should talk about, when this bill 1506 was put forward, the Attorney General's office asked for $26 million. They got $13 million. They got half of what they were supposed to get. And when I asked Kevin McCarty, who put the bill together, why did it work this way, he just said, well, we'll see what they can do with 13 and we'll see what happens if they need 26. So I don't know if that's playing a role in it. We're trying to report that out. None of the folks on stage, I don't think, could conclusively say it, but probably more money would be better. I would assume most folks would think that. We got a lot of questions sent via email. Dozens, maybe hundreds, which I haven't seen before. So we're going to get to some of them. Let me start by saying there is actually a uniformed officer on stage. Ed, I didn't know you'd be coming in uniform when I wrote these questions. When I told California's largest police union, because they wanted somebody here, we couldn't make it work, they said that Ed was going to be here. They said, okay, that's pretty good. We're okay with that. So, Ed, you are going to be speaking on behalf of pretty much every cop in California. Welcome.
This is a no comment.
Yeah, exactly. Well, yeah, these are the email questions. These are the no comment. You can tell them no comment. Can't say it to me. So this is our first email. Here we go. I do not understand, quote, how people can use the excuse that they were scared for their life when the victim was not armed and they're a police officer. Ed, can you talk about, we talked about this in the story. We talked about an unarmed person who was shot. So more broadly, what generally are police saying when they find out someone's unarmed but they still fear for their life?
The bottom line here, that is standard. That standard for using deadly force has always been, decades. It goes back decades. You will have heard that statement when I started, almost, I hate to say, over 25 years ago. But again, these incidents happen so rapidly to the point where there is no time for an officer to think. And even the court cases, Supreme Court of the United States, state courts have said in analyzing these cases, recognize that the officer had no time to think, nor do we want that officer to be thinking at the risk of him being killed. So when an officer reasonably perceives a significant threat to his or her life, then training and experience and just human nature is going to kick in automatically. And deadly force then typically results from that decision-making process. But you have to keep in mind that decision-making process is not always deliberate. It's split second. Yes, there are those situations where you see on TV where the officers are pointing their weapons for many seconds, and they're thinking. Well, in that situation, yeah, there are just different variables. One officer may perceive a movement of the gun being pointed at his or her direction or at the direction of his or her fellow officers, and that officer has to make that split-second decision whether or not he or she needs to use deadly force to protect himself or herself. So yes, bottom line is, yes, I was scared. I was scared at that moment, and the reason I was scared was XYZ. I've had officers tell me, Ed, spontaneously in my investigations, I thought I was not going to see my wife or my family that night unless I shot that individual. That was a situation was just very instantaneous, but there was enough time for him or her to contemplate that last thought before using deadly force. So.
Sure. And one thing we should note for 1506 or anything when it comes to unarmed. Unarmed does not mean that somebody's hands were empty. What it means was that the thing that they were holding was not considered a deadly weapon. So that could be something that you used to bludgeon, that's still not considered a deadly weapon. There are airsoft rifles that to the naked eye look kind of like guns. They are not, because they shoot soft pellets. If they shoot hard pellets, by contrast, they are deadly weapons. So,
Nigel?
Yep.
You brought up the point. So AB 1506, as Diana was talking about, the genesis. Preceding George Floyd was the Stephon Clark shooting. And that was definitely an impetus for 1506. Keep in mind, Stephon Clark was not armed. The object in Stephon Clark's hand was a cell phone. But given the dynamics, the environment, the lighting, all the other factors involved, the officers were determined to have reason to believe that that cell phone, when they saw the glitter, the reflection, it was being pointed at them, and they thought it was a gun, based on all the circumstances as to why they were at the call to begin with, et cetera. Keep in mind, both the DOJ and the federal government cleared those officers in that shooting. But that was that's a very, I hate to say good example, but very imperative example of a situation where the individual is unarmed.
right, another email question. This one we will throw to Greg. There's a new law that says that we, the public, can get police records, police disciplinary records under certain conditions. Do you know why this would either be a good thing or a bad thing, benefit or problem for the public and for police officers?
Well, the new law, as I recall, limits the access to those records where there are sustained findings of misconduct. It can be misconduct involving use of force, misconduct involving demonstrated bias against a particular group, or some other clear act by a police officer for which they were disciplined. For the public, it's good for transparency. But for officers, I think the understandable concern is not unlike all of us as employees. We have an expectation of privacy in the confidentiality of our personnel records. And so when it comes to peace officers, we have to understand peace officers don't show up for work an evening thinking they're going to shoot somebody that evening. It's a noble profession. We ask peace officers to do things that most of us would want to have nothing to do with, to go into dangerous, volatile, very dynamic situations and risk their life to protect others. And, you know, from 4 decades of working with police officers, I have to say the overwhelming majority of peace officers are people that are committed to doing what's right, what's good, and what's going to protect the community they serve. Certainly, we've had examples of peace officers that have engaged in misconduct, and I think principled peace officers would be the first ones to tell you that person shouldn't be part of my profession, my discipline. But I think there's an expectation of a certain degree of privacy in their personnel records. The other thing, Nigel, that's important to point out is with SB 2, another piece of legislation that changed the law, we now have a process for taking those officers who have engaged in sustained misconduct and decertifying them so that they cannot be a peace officer where they're currently employed nor any other agency, because we do have instances where an officer was disciplined by one agency, maybe terminated by one agency, and then goes on to get hired by another agency. SB 2 changed the law so that those officers can be decertified. But I think it's striking the effort should be to strike a balance between recognizing the inherent difficulties and immense authority of peace officers and their rights to certain privacy protections as well.
And as you note, that's limited to sustained complaints. What we've been hearing and what I'm reporting soon is it looks like some departments are sending all the complaints, sustained or not, up to the state and then making them public. So we'll see. We'll be getting both sustained and unsustained from some places.
Not just the departments, but anybody can submit an online complaint through the complaint portal. So, it's wide open. It's just not the respective departments.
Coming soon from CalMatters. We'll get into that one. Diana, California is a big, diverse state. Something I neglected to mention is Diana is a longtime judge and past president of the National Association of Women Judges. So we talked earlier about representation. We talked a little bit about who's doing the investigating. In a state this diverse, how does the representation, ethnic, racial, gender, of the investigators match or matter or not with the investigating that they're doing when it comes to either use of force cases or just crime in the community?
Well, I don't have the statistics about investigative staff statewide, so I'd be a little bit hamstrung to be able to answer that part of the question. But I think that more importantly, in our individual offices and also statewide, is recognizing the importance of diversity and the importance of diverse ways of thinking, the diversity in gender, diversity in ethnicity. In all of those ways will bring so that we actually, in these positions, represent the people of California in a significant way. So I think that's what's more important, is striving to be able to, in our individual offices and also in our statewide positions, to be able to have a staff that really is representative of the people of this rich state of California.
Sure, and for, I guess I'm thinking for officer-involved shootings in Contra, Costa County that, you've been responsible for investigating. Does the place in which they're taking, where they're happening matter? Does the community in which it's happening? Because we've seen it certainly in around the state. We've seen multiple incidents of, the highway patrol being involved with it, or the sheriff's department, or locals. Does it matter who's actually you're investigating in that case?
Well, it shouldn't, and I think one of the things that Greg did a good job of earlier was really talking about our responsibility as prosecutors. So one, you've got the investigative role, and we would hope that our investigators would go out and do a comprehensive and neutral investigation that's fair to all sides, but that in addition to that, as prosecutors, we would take our responsibility appropriately and seriously to be able to make sure that when we are investigating, that we are only bringing forth those cases where we have a really good faith belief that we can prove charges beyond a reasonable doubt.
Sure. Thank you for that. In a lot of these videos, we see people, this is for you, Ed, we see people in states of crisis, and they, some of them end with shooting, some of them end with non-lethal use, some of them end with getting talked down. What kind of training is happening right now in terms of de-escalation for police?
Nigel, I'm always, I don't want to say fond of telling this or explaining this to audiences, but de-escalation training was taking place before I became a cop. And I wrote about this for the California District Attorneys Association in an article I was asked to write about the myths of force by police. And one of them was that some think tanks or proponents were saying, this is brand new, this type of training, de-escalation, this is going to be a game changer, et cetera. No, that has always been part of the training curriculum. I can distinctly remember being trained in de-escalation at the academy, like I said, over 25 years ago. But again, de-escalation is good. I mean, it's effective, especially when combined with specialized, say, psychiatric evaluation response team, which typically is a team of a trained psychological expert, usually Department of Mental Health, and an officer who responds to these types of situations. But they're only utilized in those situations where there is not going to be a threat to the civilian. Because, we're not going to put a civilian psychologist or psychological expert in the line of fire. It's just not going to happen, and you don't want that. So yes, in terms of a long-range monitoring program, that can be very effective, and it is. But in these situations where an individual is waving a knife, threatening, I'm going to come at anybody that comes near me, or has some kind of deadly weapon, no, that is going to be the officer's job. That's what you pay the officer for, is confronting those dangerous, volatile situations. So we do try at that point where it's just officer with subject, try to de-escalate as much as possible. Unfortunately, it just doesn't work a lot of times, and there's just a number of reasons for that. So I know that's kind of a general response, but it is. But I will tell you this, the trend now is that for suicidal individuals, ones that are threatening only to harm themselves, generally we are just not going to respond to those calls anymore. And I can speak on behalf of a number of departments that have taken that have adopted that approach, because again, we show up in those situations and bad things happen. And typically 99% of the time, I don't have any statistics on this, usually by not showing up, it resolves itself.
Greg, do you want to add something?
Just to add a few caveats in this area, it's estimated nationally that about 25% of the officer-involved shootings involve individuals in mental health crisis. Here in California, I think the estimate is more like 33% to 50%, that range. Law enforcement confronts and deals with mentally ill people almost every day in communities across the state and across the nation. That's why many agencies, the agencies in the jurisdiction that I served, have engaged in a huge effort to provide crisis intervention training on mental health to individual officers. Officers are trained, officers are taught that their responsibility is to take control of a situation as rapidly and as quickly as possible. Well, in dealing with the mentally ill, we've learned that that's not always the best use of their authority. It's not always the best approach. Sometimes you need to slow things down. So in addition to having the crisis intervention teams that include actual psychiatric experts that Ed spoke about, we're also statewide training officers on crisis intervention, and when they confront somebody that's mentally ill, how to deal with that situation. One other point that I think is closely linked to this that we need to recognize in terms of just numbers. As I mentioned earlier, about 1,000 people are killed every year in officer-involved shootings in a variety, I mean, this is across the country. If you look at that number and then you compare it to the number of police-civilian interactions, those cases represent about 200 thousandths of 1%. That's a decimal point with 4 zeros and a 2. So they are an infinitesimally small fraction of all these interventions that law enforcement are expected to have on a day-in, day-out basis with civilians in their respective communities.
The DOJ estimate was about 140 to 160 police shootings a year, of which they estimated before 1506 was about 40 per year, 40 to 60 per year were of people who were unarmed or holding something that wasn't considered a weapon. What we've seen since then is of the cases they've taken, it's been about 20 per year. It's almost 40 now. Diana,
I'm sorry. One point I wanted to make. There is a very significant statistic, and it's not by any means, it hasn't been looked at extensively, but there are studies, but there are estimates, a significant percentage of these shootings of these individuals is by suicide by cop. It's demonstrated. They purposely have set up the officers to be killed so that they could be killed. We cannot deny that.
Sure. Sure. I think some groups might push back on the term suicide by cop, but yeah, sure. I mean, take it understood that they know that they might put themselves in danger. Diana, it might help to define what a progressive prosecutor is when I ask this question. But this is another email question. It says, what is some of the low-hanging fruit? What are some immediate observable changes that we can make in terms of police civilian encounters and again, maybe in steps to reforming behavior? And maybe it'll help to explain what a progressive prosecutor is.
An interesting question. So I really consider myself to be more reform-minded than the use of the term progressive. But in general, my philosophy is really trying to make sure that we have a system that is fair and just and equitable to everyone, that really focuses on reducing the racial and ethnic disparities in our criminal justice system, and that also focuses on reducing our footprint in incarceration and looking for alternatives to incarceration where it is safe in our communities to do so. And there was a second part to your
Yes,
question?
of course, on this one. So given that mindset, so where you're coming from, what's low-hanging fruit? What is something that civilians who want to get involved, maybe at the local politics level or just in the general discussion, what's something that could change in terms of reforming the civilian-police interactions? And there may not be low-hanging fruit, but maybe you can.
Well, I don't know if I would call it low-hanging fruit, but I know some of the concrete things that have taken place. One that I think has a significant impact is the crisis intervention teams, so that when officers are going out on calls, especially for those who might be in crisis, families that might be in crisis, there is a trained professional there to help de-escalate the situation. I think we've had some changes in the law, which have been significant. We're here today talking about 1506, but also 1392 was a significant change. I mean, the standard for reviewing the officer use of force hadn't changed in 100 years, so that was a significant change for us in California as well. I think there are lots of other places that we can think about. One is making sure that our community is educated, and also reviewing the work that we're doing. We are publishing reports that are all online. Many offices around the state of California, you can go online and see the reports. They're pretty extensive to really help people understand how we reach the decisions that we reached in cases where charges are not being filed. In Contra Costa County, we also have a community academy, which people can sign up for. We're recruiting for that right now, which really gives people a great overview of what the criminal justice system is all about and how not only with that understanding, but also how people can be involved. And then last but not least, just the low-hanging fruit, I think there's plenty of things that we can think about in terms of diversion programs that have already been implemented in many offices around the state of California. Diversion programs for our youth, keeping them out of the criminal justice system, giving them alternatives, have been very significant for us in Contra Costa County in terms of reducing the violence in our communities. And then last but not least, having the community involved. We also have a neighborhood restorative partnership so that we actually involve our community in resolving low-level nonviolent cases using a restorative justice lens. So those are all ways that citizens can be involved in reducing our footprint in incarceration and also reducing violence in our communities.
Thank you for that speed run through reform prosecutors. Yes, if we do have audience questions. Okay, let's start. Okay, here we go.
So I was looking at some data comparing the training that American cops go through compared to other countries. And in 100 developed countries, America's one of the lowest in terms of how much training a cop gets.
And by that, you mean specifically how many hours they need before they're certified?
Yes.
Let's go down the line. Ed, what do you think about that?
Oh, I'm sorry. Yes, I'm familiar with some of those studies and, or statistics, so to speak, yes. I really can't speak to that. Different countries, we're talking about different countries, different customs, different cultures, a different way of looking at law and order, so to speak. Some of these countries don't allow their officers to carry firearms, as we know. So there's a different approach when it comes to training, for those respective countries. For the United States, and typically the countries you're referring to, they have uniform police departments. In other words, the police department there's one police department for the entire country. In the United States, we have thousands of different departments that have. So it's very respective to the community's needs. That's about as, that's best I can address it.
Sure. Anybody else have a thought?
Can I have a follow-up on that? If it's seen as a helpful thing to have more training for American cops, is there anything being done in that regard to increase the amount of training for American cops?
Oh, we're training constantly. More training. Departments are screaming for more training. I do training for departments across California. Believe me, there is a high demand. But as we talked about earlier, cost is a huge issue. When you're talking about yanking officers out of patrol or their functions and sending them to, say, Sacramento from up in Modoc County or Del Norte, that's very expensive, and especially for these small departments, they can't afford the loss, even the temporary loss of manpower, to their communities. Larger jurisdictions, say like Sacramento, San Francisco, they're in those areas where they are training environment rich. So yes, again, it's going to be respective to the community, the community which the training is available.
Thank you.
And just to your point also, politically it seems unlikely right now that they would adjust the standards for California cops, only because a lot of departments are having trouble getting police officers to pack background as it is. So we did some story back in November where Tehama County doesn't have sheriff's office daytime patrols anymore. There aren't enough patrol officers. So yeah, it's just wide open country all day. And so it seems unlikely that there would be. We have a question about rural stuff here we'll get to if we have a minute. But anybody else? Evelyn, we have the next one.
So Ed, you mentioned that when the officers are in that situation, they're fearing for their life. Why aren't tasers used as an option, especially if the person is unarmed?
Yeah, no, tasers are definitely an option, but if the officer is perceiving that there's just not enough time to even deploy a taser, or it's not appropriate, because I hate to use this old adage, you don't bring a knife to a gunfight, so to speak. But if the individual is charging you with a knife and it's only 10 feet away, a taser is not an option just because of the time and distance dynamics. There's that taser, there's no guarantee that's even going to work on an individual typically. But if the individual is presenting a deadly threat to the officer is trained and justified in using deadly force to defend himself or herself against deadly force in circumstances. We don't want, I know what you're asking. We always want to use the option that will or may stop the individual without resorting to deadly force. But do we want to impose that requirement on an officer to deliberate whether or not, oh, maybe I should use a taser first, and then I'll go, if that doesn't work, then I'll use my gun. There's no time for that. Now, if you have 6, 7 officers there, so you have a plan, you have a less lethal, maybe one has a beanbag, one has a taser, the other one has a baton, and then you have the lethal officer, then oftentimes that is a tactical approach. And we do utilize that approach often, but that's if you have those resources. But as Greg was talking about, a lot of these cases, it's one-on-one. That officer is by himself or herself with the one individual, and in that split second, had to use deadly force. No backup, no other options. So, every situation, I know you hear this all the time, it's very unique. And there's a lot of factors that go into the decision-making process. And as I mentioned, sometimes there's just no time to think.
I think that the fight and flight response that all human beings have is, like, biologically a huge factor in how we think about human nature, how we think about human nature in very difficult circumstances. So I actually understand what you're saying about that. But in the context of police officers and the general power that they have, and the fact that they're armed with a gun, and the fact that there are training, then the question becomes, at what point is that human instinct, also an animal instinct, to fight or flight, is reasonable? Is it always reasonable? And to what extent does that training actually compensate or prepares them for that? Because inevitably, every cop is going to be in that situation. So does that give everyone free range to just sort of do whatever it is that they do, because that's part of the way that we're wired?
That's a great point you're making, because as I stress, we're cops, but we are human beings. We don't wake up in the morning and take a magic pill to enhance our physical and mental abilities. We're not Marvel superheroes. Wish we were. We are human. We come in all shapes and sizes, different educations, different life experiences. Yes, we do go through the training and experience on the field, but again, there's no such training to, that necessarily is going to make one officer do one thing and another officer do that very same thing. There's always going to be a range of, as you put it, reasonableness, tactics. And just because one officer does one thing, decides, oh, I'm going to use a taser, but the other officer decides, I'm going to use my baton, or another officer says, I need to use deadly force, that is going to be dependent on the reasonable perception of each officer as to his or her decision to use force. And I know that's a general response, but again, I can't take any of my officers and say, okay, we're going to have meditation training this morning, and I hope that's going to help. We're welcome to any suggestions. Believe me. I wish there was an easy answer. In other words, we don't shoot to wound.
Yeah.
We shoot to stop the threat.
But I
right?
guess what I'm saying is, like, the instinct, right? I mean, like, I understand that instinct very well. And what I'm saying is the only thing that is counterbalancing that instinct, it's like if you have not that you guys are a child, but, children do the same thing. Like, if someone hits you, you might want to hit back, and you instinctively do that, and it's sort of your natural instinct. But at what point does training actually have an impact on instinct so that you slow down in whatever way that you can, even though, like, I do get that in situations, sometimes it's not that, and you're not thinking, but if you're not thinking about your training or whatever, and you're just thinking about, I have to come home to my kid, which also takes, you know what I'm saying?
No, I do.
Like,
yeah.
I sort of feel like there's opposing forces, and maybe it's because we're not being realistic about who human beings are and what they're capable or not capable of doing, or our training isn't effective for the task at hand.
I think the training is very effective along with experience. Again, it's, we're still, as I mentioned, we're still human beings. And we do react accordingly when we feel that, I think I'm going to die here. I could literally die. Again, that's going to depend, and of course, to the prosecutors, all the facts. What was the mindset of that officer when he or she decided to pull that trigger? That is going to be the ultimate inquiry. What was that officer thinking? What did the officer perceive? And yes, all those human factors are going to come into play.
Greg, did you have a thought on this or closing thoughts on this subject?
I think that's an excellent question, and it's one of the inherent difficulties that we encounter in this whole area of officer-involved shootings. I will say that police academy, 16-week police academy, which is the beginning training process for the typical officer in the state of California, is 16 weeks long. It is a stress academy. So what that means is officers are put through very stressful, highly stressful situations to kind of weed out, and they don't have 100% graduation rates. They weed out a lot of officers who, for whatever reason, don't have the emotional and intestinal wherewithal to deal with those stressful situations responsibly in accordance with the law. And then secondarily, on those human flight and fight reactions, what we try to do in our analysis is we're looking at the imminence of the threat. Was there an imminent threat to the officer or to a third party that was clear from the evidence that the officer acted reasonably in responding to with lethal force? So we should parse out some of those flight or fight concerns that you raise in the legal analysis that we do, particularly if we have a statement from the officer and statements from witnesses that actually observed the shooting in real time.
Diana, final thought? Do you have a final thought on the bill 1506 or this conversation?
Yeah, just one real quick one. I'm sorry. In terms of investigating these, I'm speaking for law enforcement on this one, is that there's a lot of nuances, and there's no way to go through all these nuances, evaluate them. But when it comes to these investigations, the investigators have to have that background. And that's why it takes a lot of time. It's a steep learning curve, but it is highly dependent on that investigator's experience with use of force, with going through these situations, being able to appreciate, yeah, I know what this officer was going through.
I was just going to say that, and this really is a good question, but really, when you're thinking about the role, the legal analysis that the prosecutors are going through, those are the kinds of issues that we really have to wrestle with, looking at the totality of the circumstances, all of the information that was known to that officer at that time, whether, and as you mentioned, the imminence of the threat, all of those factors need to come into play as we try to make a determination as to whether or not their actions were reasonable and necessary under the circumstances. But really, really good question. And I think it also goes to one other thing that we haven't really touched on today in terms of what it takes to really analyze these types of cases is also the need as we're going forward. More and more, there's a need to also bring in expert analysis so that it is not just us as prosecutors struggling with these issues, that we're also bringing in experts who are use of force experts who come in and also look not only at the totality of the circumstances that existed, but more and more they're also going to be thinking about things that we may not have had in our analysis before, like the training, like the policies, and all of those things. And so when we're talking about the amount of time that it takes, again, back to the original questions, to really come to a conclusion in these investigations, we also have to factor in the fact that more and more we're going to be needing to rely on experts as we undertake the legal analysis.
Ed, Greg, Diana, and Nigel. As you might expect, right, the deeper we get into this, the deeper we realize this could have been a 2 or 3 hour conversation, and there's so much to talk about here and so many important issues. But most importantly, we had the conversation, got some of this aired out, and I hope that this leads to not the end, but the start of an ongoing conversation about such a very important topic. I appreciate you all taking the time, traveling some distances to be here today. I know it wasn't easy. Appreciate that. As you probably know, CalMatters is a nonprofit news organization. These events are possible because of the support of our friends at Lucas Public Affairs. Many of you get our newsletter. If you don't, I'd encourage you to, at calmatters.org/subscribe, so you can keep up with what we're doing. And if you're so inclined, it's your donations that make this possible and keep our nonprofit news organization going. So thank you all very much. Stay in touch. We'll be doing many more of these events. And thank you everybody for coming, both in the room and online today. Thank you all.